Good morning, everyone. Today we are going to study Chapter 5 Judiciary. This chapter will help you to understand and know the answers to questions like what do you mean by an independent judiciary or why do we need independent judiciary? The judiciary is defined as the system of courts that adjudicates legal disputes and interprets, defends, and applies law in legal cases. The independent functioning of the judiciary allows it to not come under the influence of the government and carry on with its work. An individual can approach the court in case his rights are violated. So, what is the role of judiciary? Courts keep decision on a large number of issues that works the judiciary does are as follows. First one is resolution of dispute. Second is judicial review. Third is validating the law and applying fundamental rights. So the first is resolution of dispute. It means the judiciary resolve problem between citizens, between a citizen and the government, between government of two states and between the states and the central government. Next is judicial review. Judiciary has the right to declare the law passed by the parliament as null and void if they believe that it violates the basic structure of the constitution. And the third is validating the law and applying fundamental rights. If an individual's fundamental right is violated, then she has the right to approach the Supreme Court or the High Court. So as you can see here in the image, this is the image of Supreme Court of India that was established on 26 January 1950. As you know, the day India became a republic. Like its predecessors, the Federal Court of India, it was earlier located in the Chamber of Princes in the Parliament House, and it moved to its present building on Mathura Road in New Delhi in 1958. Okay, so what is an independent judiciary? Independence of the judiciary plays a vital role in protecting the fundamental right of the individual of a country. Other government branches, such as the executive and the legislature, are not allowed to interfere in the work of the judiciary. The courts are not under the government. The independent functioning ensures that no power is misused by the executive or the legislature. The judges to the Supreme Court or the High Court are appointed by the President after the consultation with the Governor and the Chief Justice of the Supreme Court. So what is the structure of courts in India? Indian judiciary has three levels of court, that is the District Court, High Court and Supreme Court. Okay, so District Court means these courts are generally present in the district or in the town or tehsil level. Most of the people interact with this level of court. These are also known as subordinate or district court or tehsil level court. Okay, next is High Court. High Court is placed middle in the hierarchy of judicial authority in India. Every state has a High Court that has higher jurisdiction than all district courts. And the next is Supreme Court. You can see here in the image, this is the High Court of Madras. And the High Court was first established in the three presidency cities of Calcutta, Bombay and Madras in 1862. The High Court of Delhi came up in 1966. Currently, there are 25 high courts, while many states have their own high courts. Punjab and Haryana share a common high court at Chandigarh, and four northern eastern states of Assam, Nagaland, Mizoram and Arunachal Pradesh have a common high court at Guwahati. Andhra Pradesh and Telangana have separate high court from 1st January 2019. Some high courts have branches in other part of the state for greater accessibility. So, the third part is the Supreme Court. Okay, the Supreme Court is known as the highest judicial authority of India, which is located in New Delhi, which is supervised by the Chief Justice of India. The decisions that are made by the Supreme Court are binding on all the courts present in the India. all these different level of courts are connected. So the decision that is made in the higher court is bound on the lower court. So there are different branches of the legal system. Here we have the image of district court complex in Namchi, South Sikkim. The subordinate court is more commonly known by many different names. These include the trial court or the district judge, the additional session judge, chief judicial magistrate, metropolitan magistrate, and civil judge. Okay, so next topic is what are the different branches of legal system. The different branches of the legal system are the criminal cases, or we can say criminal law, or next is civil law. Criminal law deals with offenses that are committed against the society. For example, theft, harassing a woman to bring more dowry, and murder. It metes out varying degrees of punishment commensurate with the crime committed. The civil law deals with any injury or harm made on the individual and fights for their right. The criminal cases or criminal law starts with the lodging of the FIR report with the police who investigate the crime. After the investigation, the case is filed in front of the court. But the civil law deals with any injury or harm made on the individual and fights for their right. A petition is filed before the court by the suffering party directed. In criminal law, if the accused is found guilty, then he should be sent to jail or fined. But in civil law, the court provides a specific relief that has been asked for. Okay, next is, does everyone have access to the court? क्या सबको equal right है कोर्ट को access करने का? According to the principles, all the citizens of India have access to the court in the country. Every citizen has the right to demand justice from the court. The court play a very crucial role in protecting the fundamental right of the citizen. If an individual believes that their rights are being violated, then they can approach the court for justice. The courts are available for every people, but access to the court has always been a difficulty. The legal procedures take a considerable amount of time, money, and paperwork. In the early 1980s, the Supreme Court started the mechanism of public interest litigation, that is PIL, to easily increase access to getting justice. It allowed people or organization of a country to file complaints in front of the High Court or the Supreme Court whose rights are getting violated. One can submit a letter or telegram addressing the High Court or the Supreme Court would be treated as a PIL. Okay, when the court takes a long time to provide justice for a case, then it is said that justice delayed is the justice denied. Okay. So here we have the number of judges in India. Supreme Court sanction strength is 34 and the working strength is also 34. There is no vacancy. High Court's sanction strength is 1079 and the working strength is 655 and the vacancies are 424. District and subordinate courts have the sanction strength is 22,644. The working strength is 17,509 and the vacancies are 5,135. So, however, in spite of these, there is no denying that the judiciary has played a crucial role in democratic India, serving as a check on the power or the executive and the legislature, as well as in the protecting the fundamental right of citizen. The member of the Constituent Assembly had quite correctly envisioned a system of court with an independent judiciary as a key feature of our democracy. So, we can say the judiciary system has played very important role ताकि हमारे जो फंडामेंटल राइट्स हैं वो भी प्रोटेक्ट हो सके, साथ में जो लेजिस्लेचर है और एग्जीक्यूटिव है वो भी ईजिली वर्क कर सके. ओके, दैट्स इट. थैंक यू एवरीवन.